colleague, I just would like to share with all of you, some of you may be aware that we have a memorandum of understanding with the Masaryk University from Czech Republic, from where Professor Michal belong. And I had visited that university, and I had a great occasion to meet other colleagues also there. And it was a wonderful university. It's been considered as one of the best university of Czech Republic, and we are honored to have our association with this university. And Professor Michal is also taking care of the International Relations Office, and we had a meeting a couple of times during our International Association of Law Schools, and I was really impressed the way in which Professor Michal was driving the internationalization at his university. It's a great honor to welcome Michal to this International Teaching Month. We had a discussion earlier when I visited your university that your area is a tax law area, and we really took this opportunity to request you to deliver a talk on the principles, general principles of tax law, and thank you for accepting it. It's a great honor to have you over here. Thank you.
You're welcome.
Thank you, ma'am. So let me introduce to all our participants our guest of the day, Professor Dr. Michal Radvan. So the Professor Michal Radvan is Vice Dean for Foreign and External Affairs at the Faculty of Law, Masaryk University, Czech Republic. And also, sir is holding the post of Associate Professor of Financial Law at the Department of Financial Law and Economics. And he specializes in tax law. He is the author of 5 books and co-author of approximately 55 books. So he has presented his scientific research in more than 90 reviewed articles in prestigious journals and conference proceedings. He is a member of the European Association of Tax Law Professors and Information and Organization Center for the Research on the Public Finances and Tax Law in the countries of Central and Eastern Europe. And Professor Michal is going to deliver his talk on tax drafting principles today. So now I will just request Professor Michal to deliver his talk on tax drafting principles. Professor Michal.
Thanks so much. Thanks so much. Good morning from the Czech Republic and good afternoon to India, because we have very morning and very cold weather at the moment. Everything is frozen. Just let me start the presentation. Hopefully you can see it. Just show me that it works. Thanks so much. So I will talk about tax law drafting principles today. You have heard that my specialization is tax law. Tax law is not accepted as a branch of law in this country, unfortunately. So that's why we are part of financial law. But before I start with this, okay, somehow I have to, okay, here is the next slide. I want to tell you something about my university, my faculty, my city, because I'm not sure whether you are really familiar where Masaryk University is situated. You can see the map of Europe, and in the heart of Europe there is Czech Republic. It used to be Czechoslovakia until 1992, but now we have 2 separate states, Czech Republic and Slovakia. Sometimes the country is called Czechia, but we don't like it very much because it looks like Chechnya, a part of the Russian Federation. So we prefer Czech Republic, but okay, the official title is really Czechia in United Nations. Because of our president, he simply decided so, but we don't like it. And the second largest city in the country is Brno. Is the center of Czech judiciary because all the main courts are situated here. It has, of course, historical reasons because there was Czech lands with Prague and Slovakia with Bratislava, and we were somewhere in the middle. So the Constitutional Court is here, the Supreme Court, Supreme Administrative Court, Ombudsman is situated here, the Office of Prosecutor is here. So we do have a perfect relations between the faculty and these courts. And a lot of our students are working at the courts as assistants. As well, it's a center of education because we do have 13 universities here in the city. Masaryk University is the largest one in the city and the second largest one in the country. But in the city, we have some 90,000 students. Masaryk University has some 35,000 students. We were founded in 1919 and we are the second oldest university in the Czech Republic. Of course, Prague is the first, 1348. So it took ages to create a second university. At the moment, we have 10 faculties and our faculty of law has some 3,000 students. So you can see it's a nice place to go because you can stay in a student city, beautiful city. What I say very often, the highlight is very cheap beer because we are the beer nation. And if you pay more than €2 for a half liter of beer, then it's expensive. And don't buy it. You should find some cheaper one. It's better to, if you travel to Brno, it's better to go to Vienna, Austria, and then take a train or bus to Brno. It's better than to go to Prague. It's much shorter way from Vienna. And as well, we are in UNESCO list with the Villa Tugendhat, beautiful spot to see, beautiful villa. And on the top, you can see the law school. This is the building of our faculty, and Purvi knows that very well. But why I'm here to talk about taxation, tax law, and how the tax law should be drafted. I have to start with quite a specific method of tax law regulation. If we compare the methods of regulation in different legal branches, we can see that there are a lot of specifics in taxation and tax law. Essentially, it's a modified version of the administrative law method. However, there is much lower level of applying substitutory regulations in tax law, especially because of the principle nullum tributum sine lege, meaning no act without law. That's why there are not many substitutory regulations. Of course, there are, mainly if we are talking about local taxes. If local taxes are adopted by local councils, definitely it's not law, but there must be a permission for the local councils to adopt local tax law. Country didn't want people to be free to run their own business, for example. So we could see in tax law regulation that there were extremely high taxes on incomes from business. If we counted all rates, it was more than 100% even. So there was the last sentence that the maximum tax rate is only 85%. So people were not running their own business because they paid most of their profit to state. So this was how tax law was affecting the economy. And of course, we can still see a lot of these regulations in taxation. So we can regulate some behavior, or we can even stimulate some behavior. For example, we want foreign investments in the country. We can offer them some tax holiday for a certain period. The other thing is that we have a lot of private law elements in taxation. It's mostly the contract. If we don't have money to pay the taxes, we can ask for postponing tax payments. But it's a contract between the taxpayer and the tax administrator. We can ask for a lump sum tax. It's again a contract between the taxpayer and the tax office. And we do this contract before the period starts even. We have payment calendars, again, some type of private law contract. And we are delegating a lot of powers to private law entities. For example, talking about withholding taxes or pay-as-you-go taxes, talking about the relation between the employer and the employee. As an employee, in fact, I have no duty to the tax office because my employer, my university, is administrating my taxes. They are withholding a part of my income as a tax, and they are sending this money to the tax office. Because state believes that I am just a stupid employee, and I have a clever employer who is good enough to administer my taxes. While if I'm a businessman, I have to do everything by myself. And this is the self-application, the most important specific in tax law regulation. Because in all other branches of law, I have always somebody who is communicating with me, who is telling me what to do, or the law is clear enough or respecting the normal life, so that if I have if I want to build a house, I don't have to study the construction law. I just go to the office. I ask the lady sitting there, what shall I do? Because I want to have a house. And she's telling me what to do. But in taxation, I have no way to go to any lady at the office, showing her all the receipts I have and asking her how much. I have to know the law. I have to know that I have to file the tax return, what form of tax return it should be, when it should be filed, how much shall I pay, when, what is the form of payment. So I have to apply tax law on my situation, on my person, and this is something we don't have in any other branch of law. Plus, of course, we can talk about mandatory nature. Mandatory nature is moderated in certain instances with the element of choice. We have a possibility to apply lump sum expenses and not real expenses in personal income tax. We can be voluntary VAT payers. Sorry. We can choose the method of depreciation. We have a possibility of lump sum expenditures for income taxes. So we have a lot of specifics, and these specifics must be respected when tax law is drafted. The tax law regulation must fulfill very strict requirements, respecting the terminology used in other branches of law. The legislator should be receptive to the economic aspects of private life and of business life. And the regulation should be not only perfect, but as well easy to understand and to be applied by those stupid, sorry for this, stupid taxpayers and clever tax administrators. Let's talk about tax law drafting principles, because they play an important role in the process of tax law drafting and tax law application. These principles consider both the public interest and tax subjects' individual interests or interests of other tax law addressees. The principles allow the postulates of a rational tax system's functioning to be formulated. And the legislator should respect basic legal principles given by the Constitution, first, principles generally valid for the legal culture applied in the country. For the Czech Republic, it's continental legal culture. And third, principles valid for the democratic rule of law. And let's talk about individual principles. I would say that there are several basic principles that must be respected in every situation, in every time. And these principles are mostly mentioned in the constitutions of every country. And the most important principle is nullum tributum sine lege, meaning no taxation without representation. We have several cases in a history of the Czech Republic where these principles were not respected, mainly in the area of local taxation. there are many local councils preparing a tax law regulation at the local level, but not respecting the act on legal charges or legal taxes. And they were introducing completely new local taxes. Of course, this principle was broken. In case of normal, I would say state taxes, this principle has never been broken, but at local level is much weaker and not so specific in respecting this principle. The other principle is non-erecture activity, lex retro non agit. It means that there is a prohibition of taxation of facts that occurred in the past, meaning the obligation arising during the effectiveness of a particular regulation is governed by this regulation until its fulfillment. Of course, it's a basic principle, but we can see a lot of examples when this principle was broken. And it might be broken if it's good for taxpayers. So we have quite a nice example from the last year here in the country. The government decided to abolish tax on acquisition of immovable property. And they did it in September, but it was retroactive. They said that the act is in force, effective, from the beginning of April. Even it was adopted in September. Moreover, it was applied for all the situations when the transfer of the property was registered in the cadastral, but again, back to there was the time limit 3 months till the 3rd month after the registration of the transfer, meaning that it covered all the situations, all the transfers done in the cadastral from the beginning of December 2020. So we are almost 1 year back. And of course, I expect a lot of court trials in this case, because it's based on the registration of the property, not on the contract of the between these two parties. So it was in fact based on the decision of the official working at the cadastral office when the transfer was registered in the cadastral. So probably the principle of equity was broken here, or might have been broken here. We will see what will be the decision of the courts. The other basic principle we have to respect is the priority of international law, and as we are EU member states, we have to respect as well EU law. Especially the indirect taxes are widely harmonized, and we are free to set only the rates for VAT and for excise taxes, taxes on spirit, tobacco, and so on. So this might be for some kind of obstacle for national regulation as well. Here is the group of self-application principles. Tax provisions should be included in separate legal acts. So I would never expect any tax regulation in the act not dealing primarily with taxation. But we had this situation in a history, and it's in other countries, it's quite frequent. Here we had the exemption for some kinds of forests in the Forest Act, but it was tax exemption. I have to tell you, because of self-application, almost nobody knew that. And people were paying taxes even if the property, the forests were exempted from taxation. As well, it is necessary to follow a uniform terminology in law. with terminology, it's extremely difficult to explain it, especially to the international audience, because we are using very specific terms and words in law, and not everything is possible to be translated to English or to French, or from French to English or Spanish, whatever. We have a lot of terms for taxes. In English, we have just tax, but maybe we have as well levies. We may have charges, we may have fees. What are the differences? What is impuesto in Spanish? Is it a tax or is it a levy? Is it a contribution? So this is just the term of tax. But as well, if we are talking about some tax reductions, correction components, we have a lot of terms for this. The uniform terminology is very necessary for the self-application. As well, it is, in my opinion, inappropriate to impose very unorthodox taxes or tax components. And again, I have beautiful examples from the Czech Republic, because we were using something that was called super gross wage as a tax base for incomes from dependent activities. Meaning that I'm employed by the university, and I earn 100. This is my gross wage. But they said, no, your tax base is 100% your wage plus social and health contributions paid by the employer. It was 34, later, almost 34% of my gross income. So my tax base was 134% of my salary. I was paying taxes from taxes, because especially social contribution is very often called as a tax. And if you see the structure of taxes by OECD, you can see that social contribution is a tax. So we had double taxation, internal double taxation in the country. Super gross wage was abolished last year. I will tell you later a funny story how that happened. As well, we have something that is called tax bonus. It's quite normal that you have some rules preferencing taxpayers with babies, with children. And we have as well tax preferences for children. We use it as a tax reduction. From the tax, we deduct certain amount for every child we have. But if it's a tax reduction, meaning that if you have a lot of tax reductions from the tax, you can get to zero, maybe, and the tax will be zero. But in case of tax preferences for children, we can go below zero. And if we go below zero, it's called tax bonus. I'm paying no taxes, but I get taxes back from state as a tax bonus. So it's not a contribution from state because I have a lot of babies. I have this very unorthodox tax component directly in tax law. And to be honest, super gross wage or tax bonus are examples of very unique tax components that we can find only in the Czech Republic, nowhere else. And I was asking a lot of people, I was studying a lot of tax systems. These two components are really extreme example of Czech bad tax law regulation. What else? We should have tax law regulation understandable. There is no need to apply any of the, so that there is no need to apply any of the principles like in dubio pro libertate, in dubio mitius, in dubio pro fisco. These principles are very often applied by courts when they believe that tax law regulation is not clear. Simply, the tax law regulation must be clear enough so that these principles cannot be applied by the courts from the objective reasons. But as well, we have subjective reasons because we have no tax judges. We have just regular administrative judges dealing as well with tax law, and they are not very often. Most of them are not experts in tax law, so they are helping themselves with these principles to find decision. Tax duties should be formulated briefly and clearly. It's almost funny. This is very difficult for the legislator to formulate tax law briefly and clearly because we still have to respect the economic circumstances and the new ways how the taxpayers are behaving, and they are still trying to find the ways how to avoid taxation. So if we see any new way how people are trying or really not paying the taxes in a proper way, we have to find a new regulation so that this is covered. The title of the legislative instruments must be clearly suggest that it concerns tax matters, and title is simply alpha and omega for many taxpayers. So, for example, we had that tax on acquisition of immovable property. The object of taxation was really the acquisition of immovable property. But the members of the Senate of the Parliament changed the proposal sent from the government, and they decided that it's a seller and not the buyer, the acquirer, who is the taxpayer. And it was hidden in the act. So a lot of people, a lot of sellers were not paying this tax. And when tax administrator came and asked them, hey, why are you not paying taxes? You sold the property and you are not paying taxes. They said, why? What tax? There is the only tax connected with transfers of property, and it's tax on acquisition. But they said, no, it's called really tax on acquisition and the object is tax acquisition, but the seller is the taxpayer. You are the taxpayer. You have to pay the tax. So this is very problematic if the title of the tax is not clear, and people are generally reading just the titles of these acts or titles of the taxes, but they are not going inside if they don't think that they will find necessary information. As well, we must have adequate vacatio legis. But for example, the amendments to many Czech tax acts effective from the beginning of this year were published only on the 31st December 2020. If we compare the situation with some other countries, we can see that they have a constitutional regulation of vacatio legis, especially for tax law. 2 months, 6 months, even in several countries. But we have nothing like that. Most of countries have nothing. But only 1 day before the law is effective? Really? Seriously? Nobody is ready for this situation. And I'm afraid in the Czech Republic, this is happening very often. And of course, we have as well budget law, for example. And of course, you can imagine that before the 31st of December, the state budget for 2021 was adopted by the parliament. But if they completely changed, or not completely, but really there were serious changes in tax law effective for this year, they now had this week only had to change the state budget because the tax revenues are much lower because of lower taxes adopted and being effective since the 31st of December. Here are several principles of tax justice. We have a horizontal tax justice, meaning that the same object of taxation should be taxed equally. And as well, we have a vertical tax justice, telling us that an entity with higher incomes, higher values, and so on, should pay more on taxes. And of course, when I'm debating with my students, a lot of students is telling me that the progressive taxation is fair, because it's fair that if you earn more, you should pay more on taxes, more percent. I have another group of students telling me that it's fair when the tax is linear, meaning that no matter what is the tax base, how much I earn, I should still pay 15% or 20%. And I have as well a smaller group of students telling me, no, it would be fair if everybody is paying the same fixed amount of money on income tax. So you can see that the feeling of taxpayers is very, very different. Of course, we have to respect, and it's very connected with the principle of proportionality. And as well, there is a principle of endurance. The tax must not be of a liquidating nature. It shouldn't have a choking effect. And this is secured by corrective components such as exemptions, reliefs, and so on. I have already mentioned the double taxation principle, or no double taxation principle, better. Especially in the interstate system, there shouldn't be any double taxation, but we have it, and we were talking about super gross wage. We have it as well when we are talking about indirect taxes, because, for example, if you buy a beer here, you are paying VAT and you are paying as well excise tax on beer. But the excise tax on beer creates a tax base for VAT. So it's very clear double taxation. And this is anyway how the European system of indirect taxes works. It's double taxation. The other principle, it is necessary to protect the interests of a majority and to limit lobbies of minorities. This is very difficult, to be honest, because, for example, how does this work? It's mostly in corrective components, in exemptions or tax reductions. And in Czech Income Taxes Act, we have some 400,000 corrective components. You can see how difficult it is for the taxpayer to know all these corrective components to pay less on taxes. Again, going back to the principle of self-application. But do we really need 400 corrective components? I don't think so. We have there very, very strange exemptions, like if you are working for a national transportation company, or you are a member of a family of such a person, you are traveling for free. So you get a card, and everybody else can buy this card anyway, but you get it for free, and you can travel for free. In my opinion, it's an income. In the opinion of legislator, it's an income, of course, because it has a value. But this income is exempted from taxation. I think it's complete nonsense. Why to do that? Why to have such an exemption? And I may say that I was a person that was preparing a new Income Taxes Act. It was 10 years ago. We were just two, and the deputy minister asked us to limit the number of corrective components to 30. It's impossible. We had at the end 100 corrective components. We were not able to cut any other tax component because there are clever exemptions. Like if I sell this computer, I'm using now. Shall I pay taxes from this income? Well, I don't think so. If I get any money from the state, like a pension, for example, shall I pay taxes? Well, we may discuss it, because in many countries, pensions are taxable. In the Czech Republic, pensions are exempted. Simply, in the US, it's called Christmas tree strategy. Their members of parliament are preparing gifts for the taxpayers before Christmas so that they are exempted. In the Czech Republic, we have as well Christmas tree strategy, but this is the other strategy for the legislator, being prepared for the legislator. The bill that is sent to the parliament should have only minimum corrective components, or maybe no corrective components at all. Simply, the government is sending just a tree. And members of the parliament are expected to add decorations, exemptions, reductions, whatever else. Because if we have 200 members in the first chamber of the parliament, definitely we will have 200 decorations, because everybody must have at least one because of the voter. Let's continue. Economic nature and the principles connected with the economic nature of taxation. The primal sense of taxation must be the fiscal effect for public budgets. But it is very often broken because, as we said, taxes might have reduction or stimulative functions. Tax law drafters should definitely respect the economic rules of a chosen economic model. So as we have open market economy, there is the principle of open market economy. They should know that any regulation have short-term and long-term consequences. Legal regulation of related sections of public financial activities definitely is influencing the tax law regulation. There is an impact of fluctuations in the value of money. So, for example, if we are using fixed tax rates or fixed corrective components, is it good? I don't think so. We have a lot of examples in motor vehicles tax, in dogs tax, because we are taxing dogs here. There is still the same amount of money since 1990. And in 1990, it marks 60 euros, let's say. 60 euros in 1990 was a lot of money. Nowadays, well, it's maybe only 10 euros compared to the prices we had in 1990. So we should have, and in many countries, you can see that they have some coefficients applicable to the fixed tax rates and fixed components in taxation, respecting the inflation at least. We don't have it. So we are having lower and lower revenues because of fixed tax rates, especially when members of the parliament are not taking adequate care of tax. The other issue is professionality. Well, we know that the proposals of the acts should be consulted with stakeholders, with professional committees. And it is, when it's prepared by the Ministry of Finance, all these stakeholders, or all these professional committees, as well universities, have access to the documents, and they may send some notes, and it's being discussed with them. As well, at that moment, there is an explanatory report created by the ministry, telling us why it's necessary to have a new regulation, what are the fiscal effects of a new regulation. whether it's constitutional or not, what is the international comparison, and so on. So we have, I would say, very good proposal. We have adequate explanatory report to the act. And of course, when ministry, before the ministry sends the draft bill to the government, it's as well discussed by the legislative committee of the government. And this legislative committee has several commissions. I'm the member of the Commission for Financial of the Legislative Council of the government. So we are discussing it. We are trying to find some mistakes. We are comparing the new tax law with other branches of law. So I may say that we have some 200-300 people, mostly experts in given area, who are reading the new law and trying to precise that. But what's happening later? The first non-experts in the process are members of the government, but okay, generally they are not changing anything. But then we have members of parliament. We have first chamber with 200 members, second chamber with 81 plus president. So we have 282 legislators who are not experts in law and who are definitely not experts in tax law, but they need voters. So they are changing the draft bill from the government because they are official legislators according to the constitution. And if they are preparing any changes in the parliament, there is of course no explanatory report. So very often then we can see that the explanatory report is still that one from the government, but the act is different and the explanatory report is not respecting what is written in the act. So we may see in several countries, including USA, for example, that they have something that is called close rules, meaning yes or no vote principle. Simply, here is the draft bill and accept it or not, but don't make any changes because now we believe it's precise. However, talking about the explanatory reports, very often we may see that there are completely different reasons for the new regulation than is the real fact. And nowadays, especially, we may see that in many acts, in many explanatory reports, the reason for the changes is COVID-19 pandemic. I don't believe that we have to, or what has happened, we abolished that property transfer tax. And of course, what is written in the explanatory report is because COVID-19. It has nothing to do with COVID-19 because there were efforts of many political parties in the parliament in the last 2 decades to abolish this tax. So they just used COVID-19 pandemic and did what they wanted to do for decades. This is what I was already talking about these experts and non-experts in tax procedures or legislative procedures. And I want to finish with a bad practice example, really very, very bad practice example. There was the act amending the tax law acts for the taxable period of 2021, of course, prepared by the Ministry of Finance and completely accepted by the government. But later, when the bill was in the parliament, the prime minister, who is as well the member of the parliament, came with a completely new amendment to this act, canceling the super gross wage and doing a lot of other changes in, I would say, his own from the constitutional point of view. Definitely, he has right to do that. every member of the parliament has a right to bring some new amendments. I know that the concept of super gross wage is a complete nonsense. It was criticized by myself, by all other experts for many, many years. It has nothing to do in tax law. But I don't think that the super gross wage should have been abolished in this way by the proposal not being consulted with any expert. It was just something the Prime Minister has prepared during the night. And of course, he said it's caused by the COVID-19 pandemic. Well, during the pandemic, we are losing the revenues of public budgets. And of course, if we cancel the super gross wage at this moment, we really cut the revenues a lot by tens of percents. We are cutting the revenues from personal income. But of course, all the political parties in the parliament accepted that. There was 100% for this proposal because everybody not really wanted to lower the taxes, but they still thinking about voters. And if they vote against the proposal lowering the taxes, they are losing voters. Really, this is very bad example, and I really don't think that the members of the government, if they once had a chance to prepare something, should have moral right to change it again in the parliament. So the tax law drafting principles, I may say, are generally followed, not only in the Czech Republic. However, we all are able to find in our states several cases showing that this statement cannot be applied in all situations. The principles breach is not caused by the lack of the principles, because they are unclear. I'm sorry to say that, especially because all the politicians, but to achieve a good quality of tax law, it seems to be enough to follow principles, and especially politicians must follow these principles because they are legislators. I'm not sure whether they know it very often. Thanks so much. And I will just use the opportunity to show you this slide that all students from near my university are very welcomed in Brno as exchange students. We have as well programs for PhD, and all teachers are very welcomed as visiting professors. So if you want to study in Brno, if you want to teach with us in Brno, let me know. You can see my email, or definitely all the organizers have my email, so don't hesitate to contact me, and I'm ready to answer your questions.
Thank you, Professor, for your enlightening lecture. I'm sure the lecture will arouse enough curiosity among the participants to delve more into this particular subject. We are now I will just take few questions. We have one questions from one of our Professor Yogin Batra. He's asking, what is more difficult in drafting of tax laws, whether it is substantive part or the procedural part, which is more difficult in drafting of tax laws, and why?
Thanks for the question. I think it's connected, and it's not easy to prepare the substantive part without knowing the procedures, and it's not possible to prepare the procedures without knowing the substantive law. Well, in my opinion, in case of procedure law, we have more inspiration from other countries, plus we have inspiration from other procedures national procedures. We have administrative procedure, we have criminal procedure, we have court procedure. So we might be inspired. So in my opinion, procedure law is a bit easier, just a bit.
Okay, Professor. We are having another question. In the light of increased abuse of tax treaties, do you think that there is a need for revamped role of OECD in framing of tax legislations for the developing countries?
I'm not an expert in international taxation, to be honest. But well, we may say that the drafts used by both OECD and UN for the double tax treaties are quite old, and there should be probably, or there is a time to rewrite them, or at least to think about the rules mentioned in this drafts of treaties.
Right, Professor. Another question. In the attempt to curb tax avoidance by the SSE, at times it is seen that the governments introduce exceptions and proviso, making the law to be quite complex. In this context, what are your opinions regarding the steps which should ensure that tax legislations should remain more stable for certain duration?
Stability of tax law is it's forgotten principle. I have to rewrite my presentation. I completely forget the stability, or maybe it wasn't highlighted. To have stable law, not only tax law, is essential for correct application. But again, the thing is, in my opinion, that tax law is very often discussed by the parliament almost every year, and all members of parliament are paying taxes. And because they are paying taxes, they believe they are experts in this area. When the act concerning nuclear power plants is discussed in the parliament, they are afraid to make any changes because they know they are non-experts, and they are afraid what might happen if they prepare any amendment. But in tax law, well, I'm paying tax law, I'm the taxpayer, I know how to do that.
Right, Professor. Professor, one last question. In the times when judiciary is also not having enough judges with background or expertise to harmonize the interpretation with the financial and commercial understanding, what is your opinion regarding the drafting of tax laws, especially to be more in a legible language?
Well, it probably it was at the beginning when tax law occurred quite easy. But if something is easy, you find a way how to avoid taxation. So you have to, as a legislator, react on this because you have a gap. So you fulfill the gap, but there is another gap immediately. So tax law legislators are still one step behind the reality, and that's why it's so I would say uncomplex and very difficult to understand, because we are still thinking about new ways how to regulate some behavior that might lead to tax avoidances. I was really surprised. I was that young stupid guy at the very beginning when I was asked to work on the new proposal of the Income Tax Act. And I have realized during 1 year when we were working on that I must be a real expert in many areas. We had to consult it with accountings, with other people. Simply, you need a group of people who are well educated with a lot of experience, practical experience to prepare the draft, and still it was complicated, and we were trying to make it easy, but we know it was complicated.
Thank you, professors, for these answers. Now I will request Akshit Mishra, student of 8th semester, to propose vote of thanks for the session. Akshit.
Greetings, everyone. The beauty of law is that it is an unending ocean for exploration, and fresh perspectives always offer this new methods of exploration. We express our deepest gratitude to Dr. Michal Radvan, Vice Dean for International and External Affairs Relations, Faculty of Law, MUNI, Czech Republic, for providing this fresh perspective and intricate analysis to our students who are basically naive in something as complex as tax law. We also want to thank Dean and Director, Professor Dr. Purvi Pokhriyal, for always providing us such wonderful opportunities that otherwise wouldn't have been possible without their assistance. I would like to extend our heartiest gratitude to Professor Shreya Srivastav for the arrangements at the International Office while being the head of it, and Professor Neeraj Sharma for the moderation for today's lecture. Also, all the faculty members for their presence, the students for their patient listening. Thank you all for being here.
Thank you.
Thank you,
Professor.
Michal. Thank you.
Thanks to all. It was a great time with you. Thanks so much.
Thank you.
Thank you.
And
Looking
hope to see you
forward
in
to meet
Brno
you.
one day.
Yeah.
Everybody is
sure.
very welcome.
Yeah. And you are also welcome to visit our campus. We'll be in touch and would like to see you in the next, season of our International Teaching Month on campus. Thank you.
With pleasure. Thanks so much.
Okay, bye-bye.